Imagine waking up one morning and the house you've lived in for 40 years is no longer yours. Not because you lost a lawsuit, not because you're in debt, but because the son you gave birth to, raised, and loved your whole life looks you in the eye and says, "Mom, you have nothing here." $75 million, 40 years of marriage, and a will you've never seen before. This is my story, Evelyn Carter, and I swear to you, it's much worse than you think. Like, comment the city you're viewing from so I know how far my story has come. And stay with me until the very end. I want to start by telling you something about the morning my husband died, because nobody ever asks about that part. They ask about the will, they ask about the money, they ask about Brandon and what he did and whether I saw it coming. But nobody ever asks about 6:47 in the morning on a Tuesday in March, when the cardiac monitor in room 14 of St. Albans Medical Center flatlined, and a nurse I had never met before put her hand on my shoulder and said, "Mrs. Carter, I'm so sorry." And I just sat there. I sat there in that plastic chair with the broken armrest, the one I'd been sitting in for 11 days straight. And I looked at my husband's face, which was still and pale and somehow smaller than it had been in life, and I thought, he was supposed to come home. We were supposed to have more time. Richard Carter had been many things in his life: a builder, an investor, a difficult man to love sometimes, in the early years, stubborn and private, and not always good at saying what he felt. But he had been mine for 41 years. And whatever our marriage had looked like from the outside, the big house, the charity galas, the carefully pressed photographs, from the inside it had been real. It had been ours. He died of a massive heart attack at 73 years old after a brief illness that the doctors called sudden, even though I had been watching him slow down for 2 years. I held his hand until it went cold. I was the only one in the room. Brandon didn't arrive until nearly noon. I should tell you about my son. Brandon Carter was 44 years old when his father died, and he had his father's jaw and his father's eyes and almost none of his father's character. That's not cruelty. That's just the truth, and I have spent enough of my life smoothing over the truth to feel entitled to stop doing it now. He had been, in his younger years, a charming boy. Funny, quick, the kind of child who could talk his way out of anything, and usually did. Richard used to laugh about it. That boy could sell water to a fish. And there was pride in it, real pride, the kind fathers have for sons who seem destined for something. But somewhere between 20 and 40, the charm had curdled into something else. Brandon had tried 3 businesses, failed 2 of them spectacularly, and survived the third only because Richard quietly absorbed a 6-figure loss without telling me until 2 years later. He had been married once, briefly, to a woman named Claire who left him after 18 months and never explained why, at least not to us. He lived in a condominium in the city that Richard paid for, drove a car Richard had co-signed, and came to dinner on holidays with the particular ease of a man who was never once worried about where his next meal was coming from. I loved him. I want to be clear about that. Whatever came after, I loved my son the way you love something you made with your own body, desperately, irrationally, with a ferocity that doesn't always make sense. But I was not blind to what he was. He arrived at the hospital at 11:58, and I know the exact time because I had been watching the clock for 5 hours. He walked in looking like he'd showered and dressed carefully. Navy blazer, no tie. The particular kind of casual that takes effort to achieve. He hugged me. He smelled like expensive cologne. He said, "Mom, I'm so sorry. I got here as fast as I could." I didn't ask where he'd been. I was too tired. I just leaned against his shoulder and let him hold me for a minute, and for that 1 minute, in that fluorescent hallway that smelled like antiseptic and industrial floor cleaner, I thought, at least I have him. At least I'm not completely alone. I think about that minute a lot now. The days after Richard's death were a blur of logistics and grief and casseroles left on the doorstep by neighbors I hadn't spoken to in years. There was a funeral to plan, and calls to return, and financial accounts to locate, and an estate attorney named Gerald Marsh who had handled Richard's affairs for nearly 2 decades, and who called me 3 days after the death to schedule what he called a preliminary review of the estate documents. I assumed it would be routine. Richard had always been organized, meticulous even. He kept paper files in a locked cabinet in his home office, digital backups on an encrypted drive, and a standing annual appointment with Gerald every January to review and update everything. We had talked, broadly, about the estate. The plan, as I understood it, was straightforward. Everything to me first, with provisions for Brandon after I was gone. That's what he had told me. That's what I believed. I had no reason to think otherwise. Gerald Marsh's office was on the 14th floor of a building downtown, the kind of office that had dark wood paneling and framed diplomas and a receptionist who spoke in a half-whisper. I had been there twice before in my life, once when Richard and I updated our wills after Brandon was born, and once about 15 years ago when Richard restructured some of his real estate holdings. I went alone. I thought about asking Brandon to come, but some instinct I didn't examine closely enough at the time, made me decide against it. I would go, get the documents, understand what needed to happen next. Practical steps. That was what I needed. Gerald met me at the door himself, which I thought was a nice touch. He was a tall man in his late 60s, silver-haired and careful in the way that old money lawyers tend to be. Every word chosen, nothing wasted. He shook my hand. He said he was sorry about Richard. He looked, I thought, slightly tired. We sat down. He poured water. He opened a folder. And then he said, "Evelyn, I need to be honest with you about something, and I want you to hear me out before you respond." I felt my stomach drop. That particular sentence, the "hear me out before you respond," is never the beginning of good news. "There's a will," he said, "that I did not prepare." I didn't understand at first. Gerald had prepared our wills, both Richard's and mine, and had maintained them for years. He had a copy on file. I had a copy at home, in the same fireproof lockbox where we kept our passports and the deed to the house. But 3 weeks before Richard's death, 13 days before he was even admitted to the hospital, a new will had been filed, a different document, prepared by a different attorney, a man named Clifford Hess, whose firm I had never heard of. Notarized, witnessed, apparently legal. And in this new will, Richard Carter left the entirety of his estate, the house, the investment portfolio, the real estate holdings, all of it, totaling approximately $75 million, to his son, Brandon James Carter. I was mentioned once as someone who had already received, in the language of the document, adequate provision through prior financial arrangements. There were no prior financial arrangements. I sat in Gerald Marsh's office for a long time after he finished explaining. Long enough that the light in the room shifted slightly, the afternoon sun moving past the window. Gerald was quiet. He had the good sense not to try to fill the silence. "Richard didn't do this," I said finally. "I know," Gerald said. And the way he said it, carefully, precisely, with the weight of someone choosing words for a reason, told me he meant it. He believed me. He just didn't know yet what he could do about it. I drove home in a fog. I sat in the driveway of the house for a long time. The house I had lived in for 27 years, where Brandon had grown up, where Richard and I had argued and made up and grown old together. And I tried to make sense of what I had just been told. There had to be an explanation, a mistake, something clerical, something that could be sorted out with a phone call. Richard would never, he would not have done this. Not to me. Not after 41 years. I went inside. I made tea. I didn't drink. I called Brandon. "Hey, Mom." His voice was warm, easy, the voice of a man with nothing on his conscience. "Brandon, I need to talk to you. I went to see Gerald Marsh today." A pause. Just a half beat, the kind you wouldn't notice if you weren't listening for it. "Oh yeah? How'd that go?" He showed me a will I'd never seen before, a new one. "Do you know anything about this?" Another pause, longer this time. "Mom, I think we should talk in person. Can I come over tomorrow morning?" "I want to know now." "Tomorrow morning," he said again. "I'll explain everything." He hung up before I could push further. I sat at the kitchen table with my cold tea and listened to the house settle around me. 27 years of sounds I knew by heart. The creak of the third stair, the particular knock of the radiator in the hallway, the way the wind hit the chimney in a certain way that made a low hum you could feel more than hear. I slept badly. I dreamed of nothing I could remember. Brandon arrived at 9 the next morning with 2 coffees and the look of a man who had rehearsed his lines. He set the cups on the kitchen table, sat down across from me, and folded his hands in a way that reminded me painfully of his father. "I want you to know," he said, "that I didn't plan for this to happen this way." "What way did you plan for it to happen?" He looked at me steadily. "Dad changed his will, Mom. He had reasons. He talked to me about it before he got sick. He didn't talk to me about it. He didn't want to upset you." I felt something cold move through me. Not anger, not yet. Something quieter and more dangerous than anger. "Your father and I talked about everything," I said. "Every major financial decision for 41 years. He would not have done this without telling me." "People change, Mom, especially at the end. He was worried about—" Brandon paused, and I watched him choose his next words carefully. "He was worried about what would happen to everything after you were gone. He wanted to make sure it stayed protected." "Protected from what?" "Just protected. Managed properly. I've managed this household's finances for 40 years. I know, but Dad had concerns." He picked up his coffee, took a sip, looked at me over the rim with something I can only describe as patience. The patience of someone who has already won and is waiting for the other person to realize it. "I think it would be better for everyone if we move forward without making this into a fight. You can stay in the house for now. We'll figure out a reasonable—" "For now?" The words came out sharp, sharper than I intended. But I watched them land on Brandon's face, and I watched something shift. A slight tightening around the eyes, a recalibration. "There are legal realities here, Mom." "Are you telling me," I said slowly, "that you intend to enforce this will?" He looked at me, and he said very quietly, "It's a legal document. Dad signed it. I didn't make him do anything." I stood up from the table. I don't remember deciding to. My body just did it, some deep animal part of me that refused to keep sitting down across from my son while he told me I had no legal right to my own home. "Get out," I said. "Mom, get out of my house." He left. He didn't argue, which told me something. A man with a clear conscience argues. A man with lawyers doesn't need to. Bond. The next 3 weeks were the worst of my life. I say that knowing what I've been through. I have buried a child, our first, a daughter, born too early and gone before she ever had a chance. I have sat with Richard through a cancer scare that turned out to be nothing but cost us 6 months of terror. I have survived things. I am not a fragile woman, but there is a particular kind of pain that comes from being betrayed by someone you made, someone whose first word was mama, and whose nightmares you sat up through and whose heartbreaks you absorbed into your own body because that's what mothers do. There is no preparation for that pain. There is no amount of toughness that makes it hurt less. Gerald Marsh referred me to a litigation attorney, a woman named Patricia Voss, who specialized in contested estate cases and who wore sensible shoes and had an organized mind that I immediately trusted. Patricia reviewed the new will and told me plainly that it was going to be a fight. The document was properly executed, at least on its face. The attorney who prepared it, Clifford Hess, was a legitimate practitioner with no obvious red flags in his record. The witnesses were 2 individuals I didn't recognize. "That's the part that bothers me," Patricia said, tapping the signature page with one finger. "Do you recognize either of these names? Harold Fitch. Donna Kimball?" I didn't. "Your husband's regular witnesses, the people he typically used for legal documents, were Gerald Marsh and your neighbor, a Dr. Philip Okafor." "Philip's been our neighbor for 18 years, I said. "He and Richard played golf together. And yet these are not the witnesses on this will." I let that sit. "Also," Patricia continued, "the will was executed on a Tuesday, 13 days before your husband was admitted to the hospital. Do you have any recollection of that day? Where he went? Who he saw?" I tried to think back. 13 days before the hospital meant, I counted backward, Richard had been tired. He'd been tired for weeks, though neither of us had been willing to name it as something serious yet. He had been spending more time in his office. He had canceled a lunch with an old colleague and told me he just wasn't feeling up to it. "He was home," I said. "As far as I knew, he was home all day. He told me he was resting. Were you home as well?" I went to my book club in the afternoon. I was gone for about 3 hours. Patricia wrote something down. 3 hours. That's all it would have taken. 3 hours in which my husband was alone in our house and apparently visited by an attorney and two witnesses I had never heard of to execute a will that his own longtime lawyer had no knowledge of. Or 3 hours in which someone who knew my schedule, who knew when I would be gone, arranged for exactly that to happen. I looked at Patricia. She looked at me. "Who knew your schedule?" she asked. "Who would have known you were at book club that particular afternoon?" I didn't answer right away, because I already knew. I had called Brandon that morning to ask if he wanted to come for dinner that week, and he had asked, casually, just in passing, "What are you up to today?" And I had told him, "Book club, 3 o'clock." Brandon filed the formal probate claim 4 weeks after Richard's death. There it was, in legal language, stripped of warmth. Brandon James Carter, sole heir and beneficiary of the estate of Richard Ellison Carter, deceased, petitions this court for the issuance of letters testamentary. He also sent a letter, through his attorney, a firm with 3 names on the letterhead and offices in 3 cities, informing me that as I had no legal claim to the property at 4412 Whitmore Drive, he would require the premises to be vacated within 60 days. 60 days. I had lived in that house for 27 years. I had painted those walls, planted that garden, watched my son learn to ride a bike in that driveway, held my husband's hand in the bedroom at the end of the hall, and told him everything was going to be okay, even when I wasn't sure it was. 60 days. I read the letter 3 times. Each time I read it, something inside me got a little harder, a little more still, like water cooling to ice. Not dramatic, not sudden, just a slow and inexorable change of state. I called Patricia Voss. "I'm not leaving," I said. "I wouldn't advise you to," she said. "What do we do?" "We contest the will. We request full discovery. We subpoena every document related to that filing, correspondence, billing records, meeting notes, anything that attorney kept, and we start asking questions your son may not have prepared for." "How long will this take?" She was honest with me, which I appreciated. "Months? Possibly longer. It will not be comfortable, and it will not be cheap." "Do you believe me?" I asked. "About Richard? Do you believe he didn't do this willingly?" A pause. "I believe," Patricia said carefully, "that there are significant irregularities in this document that deserve to be examined in court, and I believe that you deserve a full hearing." That wasn't quite what I'd asked, but it was enough. I had a meeting with Brandon one more time before the attorneys took over completely. He had called and asked to talk. I almost said no, but something made me agree. Maybe the part of me that still wanted to believe there was an explanation, some piece of the story I was missing that would make this make sense. He came to the house. He sat in the same kitchen chair he'd sat in as a boy. And I looked at my son, really looked at him, the way you look at someone when you're trying to see past the face you've known your whole life. And I tried to find the person I had raised. "Mom," he said, "I know this is hard, but I want you to understand something. Dad was not happy in the last years. He felt like his legacy was disappearing, like everything he'd built was just going to get divided up and distributed and there wouldn't be anything left. He wanted it intact. He wanted me to steward it." "Did he tell you that?" "Yes." "When?" "Several times over the last year or so. And yet he never mentioned it to me. Not once. In 41 years of marriage, during which we discussed every significant financial decision, he never thought to mention that he was planning to leave me nothing." "He was leaving you the house, initially." "There is no initially in a will, Brandon. There is what the document says." He shifted in his chair. "I think if you'd seen how he was at the end, how worried he was." "I was there at the end," I said, and my voice came out quieter than I intended. I was the one who was there, every day, every night. I was the one holding his hand when he died. "Where were you?" His jaw tightened. "I had a business situation." "You were 2 hours away." "Mom, you didn't come until noon, Brandon. He died at 6:47 in the morning, and you walked in at noon and you'd showered and changed and had coffee somewhere, and I sat in that plastic chair all by myself. I hadn't meant to say that. It came out of somewhere deep and unplanned, and once it was out, I couldn't take it back, and I didn't want to. Brandon's face did something complicated. For just a moment, one brief, unguarded moment, I saw something flicker behind his eyes that might have been shame. Real shame, not performed. And then it was gone. "I'm going to need the house, Mom," he said. "I'm sorry." I stood up. "You should know," I said, "that I have hired an attorney, and she is very good. And we are going to look at every piece of paper connected to that will, every signature, every filing, every communication, until we understand exactly how it came to exist." He didn't say anything. "If your father truly made that decision freely," I continued, "then I will live with it. It will break my heart, but I will live with it. But if someone helped him make that decision, or made it for him, then you need to understand that I will not stop. Not for 60 days, not for 60 years, not for anything." I walked to the kitchen door and opened it. Brandon left without another word. 3 days later, I received notice from Brandon's attorneys that they were filing an emergency motion to take possession of the property immediately, citing reasonable concern about the potential dissipation of estate assets. Dissipation of estate assets. I was 68 years old and had lived in that house for 27 years, and apparently my presence in it constituted a risk to the estate. Patricia Voss met the motion with a counterfiling within 48 hours. The judge denied Brandon's emergency request and ordered the matter to proceed through standard probate channels. It was a small victory. One procedural ruling among what would be many. But I sat in Patricia's office when she told me, and I felt something I hadn't felt in weeks. Not hope, exactly. Something more useful than hope. I felt like myself. That night I went home and I walked through every room. I wasn't being sentimental, or maybe I was, a little, but it wasn't only that. I was reminding myself what I was fighting for. The built-in bookshelves in the study that Richard had designed himself and argued about with the contractor for 3 weeks. The garden off the back porch that I had been tending for 20 years. The roses that had finally started to come in properly in the last 3 seasons. The hallway where I had a collection of framed photographs going back to before Brandon was born. Richard and me on our honeymoon, young and slightly ridiculous, squinting into the sun on a beach somewhere. I stopped in front of that photograph. Richard, 29 years old, hair too long, the way men wore it then, laughing at something. I couldn't remember what, though I had tried many times over the years to reconstruct it. Just laughing, open and unguarded, the way he could be when his defenses were down. "What happened?" I asked him. Not out loud, just in my head, the way you talk to someone who isn't there anymore. He didn't answer. Of course he didn't. But I looked at his face, at this version of him, before the weight of money and success and age had settled onto him, and I thought, he didn't do this. Whatever is in that document, whatever that signature says, the man in this photograph did not do this willingly. That was the night I stopped grieving and started fighting. Not because I had answers, not because the evidence was clear or the path was obvious, but because somewhere between the letter from Brandon's attorneys and the sound of my own voice in that kitchen, I will not stop, I had made a decision. I was Evelyn Carter. I had built a life. I had buried a daughter and helped nurse my husband through a cancer scare and raised a son alone through the years Richard was traveling for work, and doing it all without complaint because that was what you did. That was what the women of my generation did. I was not going to be erased by a piece of paper, not by anyone, not even by my own son. The thing about a battle you didn't choose is that you spend the first part of it in shock, the middle part of it exhausted, and only somewhere in the long stretch of the third stage do you find the version of yourself who was built for exactly this. I was 68 years old. I had time. I had a good attorney. And I had something that Brandon, for all his confidence and his lawyers and his navy blazer, did not have. I knew Richard Carter, 41 years of marriage. I knew how he thought, how he organized things, what mattered to him and what didn't. I knew that he kept meticulous records. I knew that he trusted Gerald Marsh completely and had never once, in 20 years, used any other attorney for anything significant. And I knew in the place where certainty lives below words, below proof, below all the legal machinery that was now grinding into motion, that whoever had written that will, it wasn't the man I married, it wasn't Richard, and I was going to prove it, whatever it took, however long it took. I was not done. The 60-day notice came and went. I did not leave. Brandon's attorney sent a second letter, then a third, each one more formal than the last, the language tightening like a knot, and each one I handed to Patricia Voss, who filed the appropriate responses and kept the legal machinery moving in our direction. It wasn't clean. It wasn't comfortable. There were mornings I woke up at 4 a.m. and lay in the dark and thought about all the ways this could go wrong. All the ways a $75 million estate with a properly notarized document on one side could simply crush a 68-year-old woman who had nothing but her own certainty that something was wrong. But I stayed. Every morning I got up, made coffee, sat at the kitchen table in the house I had lived in for 27 years, and reminded myself of what I knew. What I knew was this: Richard Carter did not do this willingly. What I didn't have yet was proof. That changed on a Thursday afternoon in early May, 6 weeks after Richard's death, when my phone rang and the voice on the other end said, "Evelyn, it's Martin Fole. I think we need to talk." Martin Fole had been Richard's closest friend for nearly 30 years. They had met through a real estate investment group in the early 90s, two men with similar ideas about how to build something that lasted, and they had stayed close through everything: business partnerships, family complications, the ordinary erosions of time. Martin was 71 now, recently retired, living in a house on the lake about 40 minutes outside the city. He had come to Richard's funeral and held my hands in both of his and said, "If you need anything, Evelyn, anything at all." I had assumed it was the kind of thing people say, the kind of kindness that evaporates once the casseroles stop appearing. I was wrong about that. "I've been hearing things," Martin said when I called him back that evening, "about the will, about what Brandon's doing. And I need to tell you something that I probably should have told you sooner, but I wasn't. I needed to think about it first." "Tell me now," I said. He was quiet for a moment. Outside my window, the garden was going slightly wild. I hadn't had the energy to tend it the way it needed, and the roses I'd been so proud of were starting to look overgrown and a little desperate. "About 6 weeks before Richard died," Martin said, "he called me. Late in the evening, maybe 9 o'clock. He sounded not like himself, slower. I thought he was tired, or maybe that he'd had a drink, though Richard wasn't much of a drinker in those last years, and he said something that I've been turning over in my head ever since." "What did he say?" "He said, 'Martin, I think I made a mistake,' just that. I think I made a mistake." And when I asked him what he meant, he got quiet, and then he said he wasn't sure he could explain it on the phone, and that he'd come see me that week. I gripped the phone tighter. "Did he come?" "No." Martin's voice was heavy with something that sounded like guilt. "He didn't come. I called him 3 days later, and he said he was feeling under the weather. I thought he meant he had a cold. I didn't push. And then the next week he was in the hospital." I sat down on the kitchen floor. I don't know why. There was a perfectly good chair 2 feet away, but my legs just went soft and I sat down on the tile and leaned against the cabinet and closed my eyes. "Martin," I said, "do you think he was talking about the will?" I didn't know about the will then. I didn't know about any of it until people started talking. But Evelyn, yes. Looking back at it now with everything I know, yes, I think that's what he meant. A mistake. Richard had called his oldest friend at 9 o'clock in the evening to say he'd made a mistake, and then he'd gotten sick before he could explain it, and then he'd died. And somewhere in between that phone call and his death, the mistake was buried in 60 pages of legal documents that gave everything to Brandon. "Will you talk to my attorney?" I asked. "That's why I'm calling," Martin said simply. But Martin wasn't the only one. Once word spread, quietly, through the network of people who had known Richard for decades, others began to surface. Not with explosions, not with dramatic revelations, but with the careful, hesitant disclosures of people who weren't sure what they knew, or whether it mattered, but felt on some level that they couldn't keep it to themselves anymore. Dorothy Harmon, who had been Richard's accountant for 12 years, called Patricia Voss's office directly. She had noticed, she said, some unusual activity in one of Richard's investment accounts in the month before his death. A series of transfers, modest in size but irregular in pattern. The kind of thing that could mean nothing or could mean something, and that she had been uncertain enough about to flag internally, but had ultimately attributed to Richard managing some year-end adjustments on his own. Looking at it now, Dorothy told Patricia, knowing what I know about the will and the timeline, I wish I had asked him directly. Would he have been able to answer directly? Patricia asked. At that point, Dorothy hesitated. That's the thing. He had started relying more on Brandon for certain things, scheduling, calls. There were a few times when I tried to reach Richard directly, and Brandon called me back instead, told me Richard was resting, that he'd handle it. Patricia brought this to me in a meeting the following week, laying it out carefully the way she did. No drama, no interpretation, just the facts arranged in order. There's a pattern forming, she said. Your husband's last weeks. Brandon increasingly inserting himself between Richard and his professional contacts. The financial transfers. The new will executed during a window when you were absent. The use of an unknown attorney and unknown witnesses. You're describing what I've been saying from the beginning, I said. I'm describing what I'm now able to document, Patricia corrected. There's a difference. What you knew and what we can prove are two different things. We're building toward the second. She was right. I knew she was right. But sitting in that office, hearing the outline of what had been done, the quiet, systematic way my son had apparently worked to position himself, to isolate Richard, to create the conditions for what came next. I felt sick in a way I hadn't let myself feel before, because I kept getting stuck on the same question. How long? How long had Brandon been planning this? Was it opportunistic? Richard getting sick and Brandon moving fast? Or had it been in his mind longer than that, some cold calculation that had been running underneath the surface of all those holiday dinners and birthday calls and "How are you doing, Mom?" conversations for years? I didn't know. I still don't know, not completely. And there is something about that uncertainty that is its own specific kind of pain, not knowing whether the son you loved was slowly, quietly preparing to take everything from you, or whether he simply couldn't resist the opportunity when it appeared. Neither answer makes it better, but the second one is somehow worse. The document question was where things got complicated. Patricia had subpoenaed the full file from Clifford Hess, the attorney who had prepared the new will. Hess cooperated, technically. He provided what he said were his complete records, but what those records showed was thin, strikingly thin for a document of this magnitude. No draft history, no record of prior consultations, no correspondence with the client beyond a single initial contact email and a confirmation of the signing date. In my experience, Patricia said, when someone is amending a major estate document, revising the distribution of a $75 million estate, there is a paper trail, there are questions, there is back and forth, there are sometimes multiple drafts. And here there's none of that. Almost none. What there is a single meeting, one documented in-person meeting, after which the document was finalized and executed 3 days later. One meeting, I repeated. One meeting. With a man in the last weeks of his life, who by multiple accounts was not in full health, who was increasingly isolated from his regular professional contacts, and who called his closest friend shortly afterward to say he'd made a mistake. I looked at her. Is that enough? Not yet, she said, but we're not done. What Patricia didn't mention in that meeting, what she told me about 2 days later, when the analysis came back from the forensic document examiner she had retained, was what the examiner had found when she looked at Richard's signature on the new will. There was nothing wrong with it, exactly. That was the maddening part. The signature was consistent with Richard's known signatures. The pen pressure, the letter formation, the slant, all within normal range. But the examiner had noted one thing, almost as a footnote. Compared to signatures from Richard's documents over the preceding 3 years, the signature on the will showed markers consistent with what she called reduced motor control during execution. Not forgery. Not necessarily forgery, but a signature made by a hand that was struggling. A A sick man's signature, I said. A signature made under uncertain physical circumstances, Patricia said carefully, which raises the question of whether he was in adequate condition to understand and execute a complex legal document. Diminished capacity. It's an argument. It's not a slam dunk. But combined with the irregularities in the process, the isolation, the financial transfers, the missing documentation, it's part of a larger picture. A larger picture. I had been living inside this picture for weeks, so close to it that I could only see fragments. A phone call from Martin, a note from Dorothy, a forensic examiner's careful language about pen pressure. But Patricia was pulling back, seeing the shape of the whole thing, and the shape was ugly. Awesome. It was Gerald Marsh who found the missing piece. Gerald had retired from active practice 2 years earlier, but he had kept Richard's files. Meticulous records going back 20 years, the annual updates, the notes from every meeting. After we spoke that first time, he had gone back through all of it. Not because Patricia had asked him to specifically, but because Gerald Marsh was the kind of man who, once he suspected something was wrong, could not let it alone. He called me on a Saturday morning. I was in the garden, finally, for the first time in weeks, actually doing something with the roses instead of just looking at them and feeling guilty. "Evelyn," he said, "I found something." I pulled off my gloves and sat down on the garden bench. "Tell me." In Richard's file, from our last meeting, 14 months ago, his January review, Gerald's voice was careful, precise, the voice of a man who had learned to say things correctly because the precision mattered. At that meeting, Richard made a specific amendment to his existing will. He added a codicil, a formal addendum, explicitly stating that no changes to the primary will should be considered valid unless executed in the presence of myself or one of 2 designated partners at my firm. I went very still. "He added a clause," I said slowly, "requiring that any changes had to go through you." "Yes." "And the new will was executed without my involvement, without any involvement from my firm, without the presence of the designated witnesses, in direct contradiction of the codicil he added 14 months ago." I sat on that garden bench, and I looked at the roses I had been tending for 20 years, and I felt something move through me that I can't fully explain. It wasn't triumph. It wasn't joy. It was something quieter and more complicated, the feeling of a thing that was true finally being found. The feeling of Richard, across whatever distance exists between the living and the dead, having done something right, having in some way I hadn't known about, tried to protect me. He had known, or suspected, or feared. 14 months ago, he had sat in Gerald Marsh's office and added a clause that was essentially a lock on the door, a requirement that any changes to his will had to go through the people he trusted most. And someone had gone around that lock anyway. "Gerald," I said, and my voice was steadier than I felt. "Does this make the new will invalid?" "That," he said, "is a question for your attorney. But what it does is give your attorney something very significant to work with." I called Patricia before I'd even gotten back inside. The weeks that followed were both the most tedious and the most important of my life. Depositions, document requests, filings and counterfilings. The grinding bureaucratic machinery of a contested estate case, which moves slowly and expensively, and with no regard for the emotional reality of the people caught inside it. There were days I sat in Patricia's office for 5 hours straight, reviewing documents, and by the end I couldn't have told you what month it was. Brandon's attorneys pushed back hard. They challenged the codicil on technical grounds, arguing that it had been superseded by the new document, that the later will took precedence over the earlier amendment. They submitted affidavits from Clifford Hess attesting to Richard's apparent lucidity during their single meeting. They argued that Gerald Marsh's involvement was not legally required, that the codicil's language was ambiguous, that this was a grieving widow trying to undo a legal document because she didn't like its contents. That last one stung. Not because it was surprising, I had expected it, but because it was the kind of framing that strips everything human out of the situation and replaces it with something cold and procedural. A grieving widow. As if my grief were the problem. As if caring about what had been done to Richard, to both of us, was the thing that needed to be examined and challenged. I said as much to Patricia. "I know," she said, It's a tactic. They want to make this about your emotions rather than the evidence. Is it working? She looked at me steadily. Not with this judge. Our judge was a woman named Honorable Frances Kellner, 60 years old, who had been on the probate bench for 16 years, and who had, by all accounts, absolutely no patience for procedural games. Patricia had appeared before her 3 times. She reads everything, Patricia told me. Every filing, every exhibit, she doesn't miss things. I found that comforting in a way I hadn't expected. Somewhere in all the institutional machinery that had been grinding against me for months, there was a person who read everything. A person who would look at what had been done, really look at it, and apply careful judgment to what she found. That was all I had ever asked for. That was all Richard deserved. I saw Brandon once during this period, by accident, outside the courthouse of all places, after a procedural hearing I had attended with Patricia. He was there with his attorneys, 2 of them, young men in expensive suits, and he was coming out of a side door just as I was leaving the main entrance. We saw each other at the same moment, across maybe 30 feet of courthouse steps, in the middle of a gray Tuesday morning. He looked tired. That was the first thing I noticed, and despite everything, despite every hard thing I had made peace with over the preceding months, I noticed it the way mothers always notice these things, with a small, involuntary pang that had nothing to do with the legal case and everything to do with the fact that he had once been a small boy who woke up at night scared and called for me. He didn't look away. Neither did I. For a moment, neither of us moved. His attorney said something to him. I couldn't hear what. And he glanced at them and then back at me, and his expression did something I couldn't entirely read. It wasn't defiance exactly. It wasn't guilt exactly. It was something murkier and more complicated, the face of someone who has committed to a course of action and is only now, maybe, starting to feel the full weight of what that means. I nodded at him, just once, not warmly, not coldly, just an acknowledgement that we were 2 people who existed and had to share a few seconds of courthouse steps before going in our separate directions. He nodded back, and then his attorney touched his arm, and they turned and walked away. And I stood there on those steps for a moment longer and thought about the boy he had been, and the man he had become, and the distance between those 2 things that I could not fully explain and could not close and had, finally, stopped trying to. Patricia appeared at my elbow. You okay? Yes, I said, and I meant it, which surprised me slightly. We walked to her car. The clouds were breaking up overhead, patches of actual sky showing through. The roses at home needed another hour of work. There was a hearing scheduled for 6 weeks out. Patricia had filed our primary brief 2 days ago, a comprehensive document laying out every irregularity, every piece of testimony, the codicil, the forensic analysis, the financial transfers, Martin's account of that phone call. Everything we had spent 4 months building assembled into an argument that could not be easily ignored. Is it enough? I asked her, not for the first time. She was quiet for a moment, the way she got when she was being honest with me rather than reassuring. It's strong, she said. Stronger than most contested will cases I've worked. But Evelyn, courts are unpredictable. Judges are human. I need you to be prepared for the possibility that this doesn't go the way we want. I'm prepared for it, I said. I wasn't, entirely. But I had learned over the course of those months that preparation is less about certainty and more about refusing to let the fear of the outcome stop you from fighting for what's right. Richard had left me a locked door. He had, in his careful, methodical way, tried to protect what we had built together. Someone had tried to break that lock. I was not going to let them. The hearing was in 6 weeks. Everything we had, every document, every witness, every careful piece of evidence, was going before a judge who read everything and missed nothing. I went home and worked in the garden until dark. The 6 weeks between that courthouse parking lot and the hearing date were the longest of my life, and also, strangely, some of the most clarifying. I slept better than I had in months. Not well. I don't want to make it sound cleaner than it was, but better. The particular insomnia of helplessness had lifted, replaced by the duller, more manageable exhaustion of someone who has done everything they can and is now waiting for the outcome. I still woke at 4 sometimes, but instead of lying there cycling through worst-case scenarios, I would get up, make tea, sit at the kitchen table, and go through my notes. The timeline, the witnesses, the codicil, Gerald's files, Dorothy's account of the financial transfers, Martin and that phone call at 9 o'clock on a night that Richard had called his oldest friend to say he'd made a mistake. I had read those notes so many times I could have recited them in my sleep, but I kept reading them anyway. Not because I needed to memorize anything. Patricia had the full picture, the brief was filed, there was nothing left for me to prepare, but because there was something grounding about seeing it all laid out. Every piece of evidence a small proof that I was not imagining this, that something real had happened and deserved to be answered. Patricia called me the Thursday before the hearing. "I want to go over what to expect," she said. "Not the evidence, you know the evidence, but the experience. Courtrooms are disorienting even for people who've been in them before. I want you prepared. Tell me." "It will be slower than you expect. There will be procedural arguments at the start that have nothing to do with the actual substance. Brandon's team will try to reframe everything, make it about your motivations rather than the facts. They will imply, not always subtly, that you are a grieving woman with an emotional attachment to an outcome rather than a legitimate legal claim." "I know. I want you to hear it and not react. Whatever they say, about you, about Richard, about your marriage, I need you to sit still and let me handle it. Can you do that?" I thought about it honestly. "I can try." "Good enough," Patricia said. "One more thing. Brandon will be there. His team may call him to testify. If they do, and if his testimony goes the way I expect it to, I need you to be ready for the possibility that he says things about your marriage, about Richard, about you personally, that are going to be hard to hear." I was quiet for a moment. "Evelyn?" "I've been married 41 years, I said. "I've sat through harder conversations than a courtroom." She laughed a little at that. Just a small sound, but genuine. "I believe you," she said. "Monday morning, 8:30, don't be late." I dressed carefully that Monday. I know how that sounds, vanity in the middle of a legal battle. But it wasn't vanity, or not only vanity. It was something my mother had told me once, a piece of advice so practical it had stayed with me for 50 years. When the world is trying to make you feel small, dress like you know exactly who you are. I wore a dark navy suit I had bought years ago for a charity benefit and never quite had occasion to wear again. I put my hair up. I wore the pearl earrings Richard had given me on our 25th anniversary. I looked at myself in the bedroom mirror for a long moment. 68 years old, gray at the temples, lines around the eyes, the particular way grief settles into a face and doesn't entirely leave. I had not always been kind to myself about my appearance as I got older. There had been years of looking in mirrors and cataloging the distance between what I saw and what I remembered. But that morning, I looked at myself and I thought, "You have fought for 5 months. You found the truth when they buried it. You are still here." I thought that was enough. The courthouse was a mid-sized brick building downtown, the kind that looked more administrative than imposing from the outside, but had the particular weight of old authority the moment you walked through the doors. High ceilings, marble floors worn smooth by decades of footsteps, the specific smell of institutional carpet and recycled air that all government buildings seem to share. Patricia met me in the lobby at 8:15. She was carrying 2 file boxes and a leather briefcase and looked like she had been awake since 5, which I suspected was true. "How are you feeling?" she asked. "Ready?" I said. We took the elevator to the 4th floor, courtroom 12. The door was wood and frosted glass, the kind that swings with a particular weight. Patricia pushed it open and I walked in behind her, and the first thing I saw was Brandon. He was already there, seated at the opposing counsel's table with his 2 attorneys. He was wearing a charcoal suit I hadn't seen before, a new haircut, the particular groomed confidence of someone who has spent a lot of money preparing to look effortless. He was talking to one of his lawyers in a low voice, gesturing at something on a document, and he didn't look up when we came in. I sat down at our table, laid my hands flat on the surface in front of me, breathed. The room filled slowly. Patricia's paralegal, a court reporter, a small handful of observers in the gallery, including Martin Fole, who had come without being asked, and Gerald Marsh, who sat in the second row with his hands folded on his knees and his expression grave and focused. At 8:52, Judge Frances Kellner entered. She was a compact woman with short silver hair and reading glasses on a chain around her neck. She moved with the particular efficiency of someone who has no time to waste and has been telling people so for 16 years. She sat down, arranged her papers without looking up, and said, "We're on the record. Carter estate matter. Counsel, announce yourselves." Patricia stood. Patricia Voss, appearing for the petitioner, Evelyn Carter. The lead attorney for Brandon, a man named Douglas Whitfield, who had the kind of face that was made for projecting reasonableness, rose. Douglas Whitfield, with my colleague James Pruitt, appearing for respondent Brandon Carter. "Sit down," Judge Kellner said, and opened the top file on her desk. "I've read the briefs, both of them. I've reviewed the exhibits. Before we begin, I want to be clear about something." She looked up over her reading glasses, first at Whitfield, then at Patricia. "This court's function is to determine whether the document offered for probate represents a valid expression of the decedent's final wishes. That is the question. I am not interested in family grievances, financial speculation, or character arguments that don't bear directly on that question. Are we clear?" Both attorneys said yes. "Good. Ms. Voss, you filed the contest. You're up." Patricia opened calmly. She always opened calmly. It was one of the things I had come to understand about her in 5 months, that she saved her force for the moments when it mattered most and spent the opening methodically, building the architecture of the argument before she put any weight on it. She laid out the timeline. Richard's death, the discovery of the new will, the contrast with the existing will, and the 14-month-old codicil, the identity of the attorney who had prepared the document, Clifford Hess, unknown to Richard's longtime professional circle, and the striking absence of any documented consultation process, the witnesses whose names appeared on the signature page and who had no relationship to Richard Carter. She was 40 minutes in when Whitfield first objected. The objection was technical, something about the admissibility of Gerald Marsh's testimony as to the codicil's meaning, and Judge Kellner overruled it with a single word. "Overruled. Continue, Ms. Voss." I watched Brandon during Patricia's opening. He sat very still, which wasn't like him. Brandon was usually a man in motion, restless, always with some small physical expression of his energy. But he sat still and looked at the table in front of him and only occasionally glanced up, and when he did, his expression was careful, controlled. The face of someone who had been coached extensively and was working hard to execute the coaching. It was the work of it that struck me. The effort it took for him to sit there and look composed. That effort told me something about how the evidence was landing. Then Patricia called Martin Fole. Martin took the stand with the quiet dignity of a man who has decided to do a hard thing and is going to do it correctly. He was 71 years old, white-haired, still broad through the shoulders from decades of physical work in his earlier years. He looked like what he was, an honest man who had come to tell the truth about something that cost him something to tell. Patricia walked him through it carefully, his relationship with Richard, the phone call, 6 weeks before Richard's death, at 9 o'clock on a weeknight. The words, "I think I made a mistake." "In your 30 years of friendship with Richard Carter," Patricia said, "had he ever called you at that hour to say something like that?" "No," Martin said. "Richard wasn't. He wasn't a man who admitted to mistakes easily. That was just his personality. He worked things out on his own and then presented the finished version. For him to call me and say that the way he said it, there was something different about it. I knew it at the time. I just didn't know what it meant. And when he said he'd come to see you to explain, he never came. He was sick before he could. And then Martin stopped for a moment, and I saw him take a breath. And then he was gone. And I didn't put it together until I heard about the will." Whitfield's cross-examination was aggressive without being effective. He tried to frame Martin's account as speculation. "You don't know what mistake he was referring to, correct?" And Martin answered plainly, "No, I don't know for certain. I know what he sounded like. I know what 41 years of knowing someone sounds like. And he sounded like a man who was frightened." Judge Kellner did not tell Martin to limit his answer. She just wrote something down. Dorothy Harmon was next. The account transfers, the irregularities, the calls that Brandon had intercepted, placing himself between Richard and his accountant in those final weeks. Dorothy was a precise woman, numbers person, buttoned up, and she gave her testimony in the tone of someone reading a report, which made it, paradoxically, more devastating. There was nothing emotional about it, just facts, plainly stated. In your 12 years managing Mr. Carter's accounts, Patricia asked, was it routine for his son to handle communications on his behalf? No, Dorothy said. It was not routine at all. It began approximately 8 weeks before Mr. Carter's hospitalization, and it was notable enough that I made an internal note about it at the time. And did you raise a concern? Dorothy paused. It was a brief pause, but I caught it. I intended to. I planned to speak with Mr. Carter directly at our next scheduled call. That call was canceled. I was told by Brandon Carter that his father wasn't feeling well and would reschedule. Did the reschedule ever happen? No. Mr. Carter was admitted to the hospital the following week. I heard a sound behind me. Something small, just a shift of weight, maybe just someone adjusting in their seat. But when I glanced over my shoulder, Martin Fole was looking at the floor with an expression that was halfway between grief and fury, and I had to look away before I felt it too completely. Then came the document examiner. Her name was Dr. Claire Ashworth, and she had been doing forensic document analysis for 23 years, and she testified the way experts testify, with precision and care and a complete absence of drama that somehow made every word land harder. She explained the analysis. The comparison of Richard's signature on the contested will against 37 known signatures from documents spanning 15 years. The findings about pen pressure, letter formation, stroke consistency. The conclusion, stated carefully and with appropriate qualifications, that the signature showed markers consistent with significantly reduced motor control at the time of execution. In your professional opinion, Patricia asked, what could account for those markers? Several factors could produce this result, Dr. Ashworth said. Advanced illness, significant fatigue, the administration of certain medications that affect fine motor function. In some cases, external pressure during the act of signing, physical guidance of the hand. The courtroom was very quiet. You're not able to determine which of those factors applies here. Not from the signature alone, no. What I can say is that this signature is inconsistent with the signatures this individual produced throughout the prior years, and that the inconsistency is significant enough to warrant serious scrutiny of the circumstances under which it was executed. Whitfield's cross-examination of Dr. Ashworth was the longest stretch of the hearing. He challenged her methodology, her sample size, the qualifications of her analysis, the degree to which pen pressure could meaningfully be interpreted. Dr. Ashworth answered every question with the same measured precision, acknowledging limitations where they existed and holding her ground where they didn't. She was unflappable in a way that I think frustrated Whitfield more than any more combative witness would have. Judge Kellner asked her one question directly. Dr. Ashworth, in your professional experience, and I'm asking for your expert judgment, not a qualified opinion, does this signature raise legitimate questions about the decedent's capacity at the time of execution? Dr. Ashworth looked at the judge. Yes, she said. It does. Then Patricia called Gerald Marsh. Gerald was the witness I had been waiting for. Not because what he had to say was more important than Martin's account, or Dorothy's testimony, or Dr. Ashworth's analysis, but because Gerald was the one who held the key, the codicil. The document Richard had added 14 months before his death, quietly and deliberately, that required any changes to his will to go through Gerald's firm. Gerald took the stand with the solemnity of a man who understood exactly what he was there to do. He explained the codicil clearly, its purpose, its language, its legal function. He explained that he had not been contacted by Richard Carter or by anyone acting on Richard Carter's behalf in connection with any amendment to the estate documents in the final year of Richard's life. To be clear, Patricia said, the new will, the document currently offered for probate, was executed in direct violation of the procedural safeguard your client had put in place. Yes, Gerald said. That is correct. And in your 20 years working with Richard Carter, Was it consistent with his character to disregard his own carefully established legal procedures? No, Gerald said. It was entirely inconsistent. Richard was methodical to a fault. He put that codicil in place for a reason. He was a man who protected what he had built. Every document, every procedure, every safeguard, it was all intentional. The idea that he would have gone around those safeguards voluntarily in the last weeks of his life without telling me, without telling his wife. Gerald stopped. He looked at me for a brief moment and then back at Patricia. It doesn't track. It doesn't track with anything I knew about him. Whitfield's cross of Gerald was brief. He had nothing to work with and he seemed to know it. Then Brandon testified. His attorneys had clearly worked hard with him. He was composed, sympathetic in effect, pitched at a frequency of reasonable son doing what his father wanted. He spoke about Richard's concerns for the estate, about conversations they had apparently had about legacy and preservation, about Richard's belief that a centralized stewardship, meaning Brandon, would protect the assets better than a divided inheritance. Did your father discuss these changes with your mother? Whitfield asked. He told me he'd spoken with her generally about his wishes, Brandon said. He didn't always give me details about their conversations. Did you pressure your father in any way to change his will? No, absolutely not. Did you arrange or facilitate the meeting with attorney Clifford Hess? A pause. Just one beat too long. Dad asked me to find someone who could help him with some estate adjustments. I gave him a few names. He chose Mr. Hess on his own. Then Patricia stood for cross-examination. She was quiet for a moment before she began, that particular pause she used when she was about to ask something she already knew the answer to and wanted the room to understand the weight of the question before the answer arrived. Mr. Carter, she said, you testified that your father asked you to find an attorney. When was that conversation? Sometime in the late fall. I don't remember exactly. Was your father in good health at that time? He was slowing down a little, but was he showing any signs of cognitive or physical decline? Nothing significant. Nothing significant, Patricia repeated. Are you aware that his accountant, Dorothy Harmon, logged an internal note around that time about irregularities in his account activity? I don't know anything about her internal notes. Are you aware that his oldest friend, Martin Fole, received a late-night phone call from your father expressing that he had made a mistake? Brandon stopped. No, I wasn't aware of that. You testified that your father chose Clifford Hess on his own, but you provided the name? I provided a few names, yes. Including Clifford Hess? Among others. Mr. Carter, are you aware that Clifford Hess previously represented a business entity in which you held a financial interest? The silence that followed was different from the other silences in the courtroom. It had a texture to it, something that hadn't been in the room before. Brandon's jaw tightened. His attorney made a sound, but not quite an objection, something more instinctive than that, quickly suppressed. Brandon said. There may have been a prior business matter. It was not relevant. You directed your ailing father, Patricia said, her voice still even, to an attorney with whom you had an existing professional relationship, without disclosing that relationship to your father or to anyone involved in his estate planning. Is that correct? It wasn't. Is that correct, Mr. Carter? He looked at his attorneys. They couldn't help him. There was a prior relationship, he said finally. It was minor. Patricia let it sit, just for a moment, just long enough for everyone in that courtroom to feel the weight of what had just been said. Nothing further, she said, and sat down. Balshaments. Judge Kellner called a recess at that point. 30 minutes. I sat in the hallway on a bench outside the courtroom, and Patricia sat next to me, and neither of us talked for the first few minutes. There was nothing to say that the evidence hadn't already said. Martin came and sat on my other side. He didn't say anything either. He just sat there, which was, I think, exactly the right thing to do. How do you think it went? I asked Patricia eventually. She was quiet for a moment. When she answered, she was looking at the wall across the corridor rather than at me. The prior relationship between Brandon and Clifford Hess, she said, was the piece I wasn't certain we would be able to establish on the stand. We found it in the business filings last week. A limited liability company, small investment 2 years ago. Enough to create an undisclosed conflict of interest in the attorney who executed the will. You didn't tell me you had that. I wanted to see how he answered the question before I knew how much it would matter. I absorbed that. And how much does it matter? She turned to look at me. Patricia Voss, who had been careful and measured and precise for 5 months, and who was now allowing herself just the smallest expression of something that looked, cautiously, like confidence. It matters, she said. We went back inside. Judge Kellner did not rule from the bench that day. I want to be honest about that because I think if this were a different kind of story, a cleaner, more satisfying kind, the judge would have looked up from her papers at the end of the hearing and delivered her verdict right there, in that courtroom, with everyone present, Brandon's face falling, the gavel coming down. Justice, immediate and complete. That is not how it happened. What happened was that Judge Kellner gathered her papers at the end of the afternoon session, looked at both tables with the same unreadable expression she had maintained for 6 hours, and said, "I'll have a written ruling within 30 days. Court is adjourned." And then she stood and walked out, and the room exhaled, and Brandon's attorneys huddled together immediately in low, urgent voices, and Patricia put her hand briefly on my arm and said, "That went as well as it could have gone." And I nodded and tried to feel something definitive and mostly felt numb. 30 days. After 5 months of fighting, after everything, the depositions, the document analysis, Martin's testimony, the moment Brandon had admitted on the stand to the prior relationship with Clifford Hess, 30 more days of not knowing. I drove home alone. Patricia had offered to drive me, but I wanted the time in the car, the specific solitude of moving through the city while everything was still unresolved. I took the long way, through the older neighborhoods, past the kinds of houses that had been standing for 60, 70 years. There is something about old houses that I have always found steadying, all the lives they have held, all the things that have happened inside them and been survived. I turned onto Whitmore Drive at dusk. The house sat at the end of the street exactly as it always had, and I sat in the driveway for a moment before going inside, and I thought about Richard. Not about the will, not about the case, not about any of it. Just about him, the specific reality of him, his hands, the way he cleared his throat before saying something he found difficult, the habit he had of reading the newspaper front to back even in the age of phones, because he said he thought better with paper. "I did everything I could," I told him in the quiet of the car. "Whatever happens now, I did everything I could." The 30 days were, in some ways, harder than the months before. Before the hearing, I had tasks, evidence to locate, testimony to prepare, documents to review. There was always something to do, some next step that kept the forward motion going. But in those 30 days of waiting, there was nothing left to do except wait. And waiting without action is its own particular form of suffering. I kept busy the way people do when they're trying not to think. I worked in the garden every day. The roses were coming back properly now. The beds I had neglected during the worst months finally tended and shaped. I had lunch with Martin twice, dinners with a handful of old friends who had stayed close through everything and whose company reminded me that my life was larger than a legal case, even when the legal case felt like everything. I read books I'd been meaning to read for years. I organized Richard's study. Not clearing it out, not yet, just organizing, because I wasn't ready to do more than that, and I didn't force myself. Patricia checked in every few days. Brief calls, mostly, no new information, just the simple human acknowledgement that someone was paying attention. I had come to understand over those months that Patricia Voss was more than a competent attorney. She was a woman who believed, genuinely, that what had happened to me was wrong, and that belief colored every hour she had put into the case. I had met lawyers before who were technically excellent and fundamentally indifferent to their clients. Patricia was not that. And in the grinding difficulty of those 5 months, that had mattered more than I could have anticipated. On the 23rd day, Brandon called me. I saw his name on the screen and I stood in the kitchen holding the phone for 3 full rings before I answered. I'm not sure what made me pick up. Curiosity, maybe. or the stubborn conviction that I should not be afraid of a phone call from my own son. Mom. His voice was different than it had been. The careful composure from the courtroom was gone. He sounded tired, hollowed out in some way I recognized because I had heard it in my own voice for months. Brandon. A long silence. I let it sit. I want you to know, he said finally, that I didn't think it would go this far. I didn't say anything. When the idea came up, I told myself it was what he wanted, that he had told me things about the estate that he hadn't told you, and that I was just doing what he asked. Was that true? I asked. Another silence, longer this time. Some of it, he said. He did say things to me about wanting the estate protected, about not wanting it split up. That part was real, but he stopped. But I knew he was sick. I knew things were moving fast, and I wanted to make sure. You made sure, I said. The word landed between us. He didn't deny it. I didn't forge anything, he said, and there was something desperate in it, the distinction of a man trying to find the version of what he had done that he could live with. The signature was his. He was there. He signed it. You put a dying man in front of a document that circumvented every legal safeguard he had put in place, I said quietly. You used an attorney you had a prior relationship with and didn't disclose it. You intercepted his communications with his accountant. You made sure I was out of the house when it happened. I stopped. Did you tell him what the codicil said? Did you explain to him that signing that document would violate a safeguard he had put in place himself 14 months earlier? Silence. Did you, Brandon? He wasn't always following things clearly at that point. I know he wasn't. My voice cracked just slightly on that. I pressed through it. I know he wasn't. That's the point. That's the whole point. I heard him breathe on the other end of the line. Just breathe for a moment. And it was such an ordinary sound. The sound of a person being alive, being in a body, being somewhere on the other end of a phone. And I felt, underneath everything, the terrible complexity of loving someone who has hurt you. It doesn't resolve into something simple. I wanted it to be simple. I wanted to feel only what the situation seemed to call for. Anger, disgust, a clean and righteous severance. But it was never only that. There was always underneath the weight of everything we had been to each other before this. I'm not going to ask you to drop the suit, he said. I know it's too late for that. It is. I just wanted you to know that He stopped again. Started again. I know what I did, Mom. I know what it was. I stood at the kitchen window and looked out at the garden. The roses, the old pear tree in the far corner that had been there longer than we had and would probably outlast all of us. I know you know, I said. That's the part that would be hardest to live with if I were you. I hung up. My hands were shaking slightly, not from anger, just from the simple physical cost of that conversation, the energy it took to stay steady through something that was not, at its heart, simple at all. I went outside and worked in the garden until it was too dark to see. The ruling came on a Wednesday. Patricia called me at 9:47 in the morning. I was in the kitchen, which is where I seemed to be for every significant phone call of those months, and I remember looking at the familiar scratches on the kitchen table. The one Brandon had made as a teenager dragging something across it without a placemat, the one Richard had tried to fix with a furniture marker and made marginally worse, and bracing myself. It came, Patricia said. Tell me. Judge Kellner ruled in your favor. The contested will has been invalidated. The court found that the document was executed in violation of the procedural codicil established by the decedent and that the undisclosed prior relationship between Brandon Carter and Clifford Hess constituted a material conflict of interest that compromised the integrity of the execution process. The court has further found sufficient cause to question whether the decedent had adequate independent legal counsel and whether his capacity to execute a complex legal instrument was fully established. I sat down. I had not planned to sit down. My body made the decision without me. The estate, Patricia continued, reverts to the prior valid will and codicil, which leaves everything, the house, the investment accounts, the the real estate holdings, to you, as Richard's original estate plan intended. I put my hand flat on the kitchen table, on the scratches, on the evidence of ordinary life, of dinners eaten and homework done, and a teenage boy being careless with furniture the way teenage boys are, and a husband making it slightly worse trying to fix it the way that particular husband always did. "Evelyn," Patricia said. "I'm here," I said. "I'm here. Give me a moment." She gave me the moment. That was one of the things about Patricia Voss. She knew when to let silence be. "What about Brandon?" I asked, when I could speak evenly again. "The court has referred the matter to the district attorney's office for review of potential financial misconduct. That's a separate process. It could result in criminal charges. It could result in nothing. That's out of our hands now. What I can tell you is that his control over the estate has been fully revoked, and that the court's language about the undisclosed conflict of interest is significant. It's not a finding of fraud exactly, but it's close enough that prosecutors will pay attention. So it's not over. The civil matter is over. The rest, that belongs to other people now." I understood what she meant. The weight of what happened next to Brandon, what the district attorney decided, what investigators found, what consequences came. That was no longer mine to carry. It was, in the way of these things, out of my hands. I had done what I set out to do. I had proved that something was wrong. I had protected what Richard had built. Everything after that was the machinery of other systems doing what they were supposed to do. "Patricia," I said, "thank you." "You did the work," she said. "I just organized it." That wasn't entirely true, but I let her have it. The formal restoration of the estate was not instantaneous. Nothing in law is instantaneous. But it moved relatively quickly once the ruling was in place. Within 2 weeks, Brandon's attorneys had filed a notice of appeal, which I had expected. Judge Kellner's ruling stood pending the appeal. The house remained mine. The accounts remained mine. The process ground forward the way legal processes do, impersonally and with no regard for the human beings at the center of it. The appeal was denied 6 weeks later. I learned that from Patricia in another 9:47 morning phone call, and this time I stayed standing. It was over. Or the legal part of it was over, which is not the same thing as everything being over, but it was enough. Gerald Marsh came to the house the week after the appeal was denied. He called first and asked if he could stop by, and I made coffee and sat with him in the living room, and we talked about Richard for an hour in a way I hadn't been able to talk about him since he died. Not the estate, not the legal case, just Richard. The man Gerald had worked with for 20 years. The particular way he had of sitting in Gerald's office and asking hard questions quietly until he was satisfied with the answer. The January meetings, every year without exception. The methodical care he took with everything he had built. He added that codicil because he was worried, Gerald said. I didn't ask him why at the time. I should have, but clients don't always want to explain, and I didn't push, but looking back at it now, I think he knew something was off. I think he was trying to protect you without alarming you. That's Richard, I said, and it came out half laugh, half grief. Solving the problem before telling me there was a problem. It used to drive me a little crazy, professionally, Gerald admitted. But in this case, it worked. We sat with that for a moment. He loved you, Gerald said. I know that's obvious, but I've worked with a lot of people on their estates, and the way a person constructs their documents, what they protect, what they prioritize, it tells you something real about what they value. Everything Richard built pointed back to you, even that codicil, especially that codicil. I looked down at my coffee cup. It was an old one, blue and white, slightly chipped at the handle, part of a set Richard and I had bought at a flea market the first year we were married, and most of which had broken over the decades until just this one remained. I had never been able to throw it away. I know, I said. And I did. I had known it through the whole thing, even on the worst nights, even when the doubt crept in and asked whether I really knew him as well as I thought. I had known it the way you know the things that are most true, not through argument or evidence, but through the accumulated weight of years. The district attorney's investigation moved slowly, the way those things do, and I tried to follow Patricia's advice and not track it too closely. There were things I couldn't control, and learning to leave them in other people's hands, after 5 months of fighting for everything myself, was a different kind of discipline. What I knew was this: the investigation was real. There were financial forensics involved now, people going through the account transfers Dorothy had flagged, the business relationship between Brandon and Clifford Hess, the question of whether any of what had happened rose to a level that the law recognized as criminal. I did not know how it would resolve. I told myself I didn't need to know yet. What I needed right now was to come back to myself, to come back to my own life, which had been on hold for almost half a year. The house needed attention, not just the garden, the whole house, the ordinary maintenance of a place that had been somewhat neglected while its occupant was consumed by something else. There were gutters to be cleared and a bathroom faucet that had been dripping since February and a section of the back fence that had come loose in a spring storm. I made a list. I fixed the faucet myself badly and then called a plumber to do it properly. I had the gutters cleaned. I took the fence section apart and repaired it over the course of 2 weekends with more determination than skill, and it came out uneven in places but solid, and I was more proud of it than I had been of almost anything in years. Martin came over for dinner one Saturday, and we sat on the back porch until late, talking about everything and nothing. He brought a bottle of wine Richard had always liked, which was either a thoughtful gesture or a slightly masochistic one, possibly both. "Are you okay?" he asked at some point in the evening, when the wine was mostly gone and the garden was dark, and the porch light was throwing its small circle of warmth around us. I thought about it. Really thought about it, rather than giving the automatic answer. "Not entirely," I said, "but more okay than I was, and more okay than I expected to be." "That might be the most honest thing anyone's ever said to me," Martin said. "It's the most honest thing I've said in a while." He raised his glass. I raised mine. We didn't say anything else, and we didn't need to. There was one more thing that happened during those weeks, and I have gone back and forth about whether to include it here because it did not resolve cleanly, and I am still not entirely sure what to make of it. Brandon called again. This was a month after the appeal was denied, which meant he had had time to absorb what had happened, to sit with the consequences, to understand the full shape of where things stood. He called on a Sunday afternoon. I was in the garden. "I'm not going to fight it anymore," he said. "The appeal. The whole thing. I'm done." "Your attorney's already filed the denial," I said. "I know. I mean, going forward, whatever the DA decides, I'm not going to make it harder than it already is." I didn't say anything. "I know that doesn't fix anything," he said. "I know it's not an apology. I don't know how to apologize for this. I don't know if you'd want one from me." "I don't know either," I said honestly. "Okay." A long pause. "Okay. I just wanted you to know." He hung up. I stood in the garden with my phone in my hand and the smell of soil and roses around me, and I thought about what it means to love someone and be failed by them completely, and whether those two things can coexist in the same heart without one of them destroying the other. I don't have a clean answer to that. I'm not sure I ever will. What I have is the house, the garden, the roses that have finally, after 20 years of tending, learned to come in the way I always wanted them to. The chipped blue cup in the kitchen cabinet, the photograph in the hallway of a young man laughing on a beach, squinting into the sun at something I can no longer remember. And the knowledge that I fought for what was right, and that it mattered, and that Richard, methodical, careful, difficult, beloved Richard, had tried even at the end to protect what we built together. That was not nothing. That was, in fact, everything. The district attorney's office took 4 months to complete their investigation. I know that sounds like a long time, and in some ways it was. 4 more months of a process that had already consumed the better part of a year. 4 more months of living inside the unresolved, of waking up and knowing that somewhere in a government office building, people were going through financial records and making decisions that would determine what kind of consequences my son would face for what he had done. But in another way, those 4 months were the first real breathing room I had experienced since Richard died. The legal battle was over. The house was mine. The estate was mine. What happened next with Brandon and the DA, that was no longer a fight I was in. It was a process I was adjacent to, A thing happening in a room I wasn't in, and I had to learn to leave it there. That was harder than I expected. I want to be honest about that, because I think there is a version of this story, the clean version, the version that wraps up neatly, where after the ruling comes in, the protagonist exhales and finds peace, and everything settles into clarity. That is not what happened to me. What happened was messier and more human, and I think more true. What happened was that I spent those 4 months in a state of low-grade emotional disorientation that I didn't fully recognize until I was mostly through it. I had been running on adrenaline and purpose for so long, find the evidence, prepare the case, fight, 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 that when the fighting stopped, I didn't know quite what to do with myself. The house was quiet in a way it hadn't been before. Not the grief quiet of the weeks after Richard died, but a different kind of quiet. The quiet of aftermath. I saw a therapist. I want to include that because I think it matters, and because there is still, in certain circles, a reluctance to admit to it, as if needing help processing something genuinely traumatic is a weakness rather than ordinary sense. Her name was Dr. Renata Wells. She had an office with too many plants and a box of tissues on the table that I used more than I expected, and she was direct in a way I appreciated. She did not let me be vague about things. "You're describing grief," she said in our third session, "not just for Richard, for Brandon too, for the version of him you thought he was." "He's not dead," I said. "No, but the relationship is, or at least the version of it you had, that's a real loss." I sat with that for a long time. It was accurate. That was the thing about Dr. Wells. She had a way of being accurate that was almost inconvenient, because once she said a thing plainly, I couldn't unhear it. The version of Brandon I had lost was not the 44-year-old man in the charcoal suit with the navy blazer and the expensive lawyers. That man I had lost some time ago, probably without fully acknowledging it. What I had lost, what I was grieving, was the boy. The quick, charming, difficult boy who had been my son for decades and who had existed, I now understood, in a way that was partly him and partly my own need to believe in a version of him that was better than the evidence. That is a painful thing to know about yourself, that some of what you were fighting for was a story you had told yourself for years. But it is also, I think, an important thing, because once you see it clearly, you can put it down. You can stop carrying it. The DA's findings came on a Thursday morning in early autumn. Patricia called me, as she always did, at a time that had become almost ritualistic. Mid-morning, just after 9, like she waited until I had had my coffee. "They filed charges," she said. I put down my cup. "What charges?" "Undue influence, financial elder abuse." That's a specific statute. It covers what was done to Richard in those final weeks. And 1 count of fraud related to the undisclosed relationship between Brandon and Clifford Hess. She paused. "Clifford Hess has also been charged, separately. The state bar has opened a disciplinary proceeding against his license." I sat in the kitchen with the autumn light coming through the window and the garden outside going gold at the edges the way it does in October, and I tried to identify what I was feeling. It wasn't triumph. I want to be clear about that because I think people expect a certain satisfaction in this moment, the moment when justice arrives formally, when the thing you fought for gets its official name and its consequences. And there was something. There was a quiet recognition, a sense of a circle being closed. But triumph requires a certain cleanness, and this was not clean. My son had been charged with crimes. The father of the boy who had called for me in the night was going to face a criminal proceeding. That was not a thing I could feel triumphant about. What I felt was something more like, it was real. It happened. The world has acknowledged that it happened. After months of being the grieving widow with an emotional attachment to an outcome, the framing Brandon's attorneys had tried to impose on everything. There was now a document in the hands of a prosecutor that said, no, this was real. This was wrong. This person did this. "Evelyn," Patricia said, "you okay?" "Asking me that has become something of a habit," I said. "It's a reasonable question." "I know." I looked out at the garden. The roses, which had come in beautifully this year, better than any year I could remember, were starting to drop their petals in the autumn cool. "I think I'm okay. I think I need to sit with this for a while." Take all the time you need, she said. This part is really done. Brandon's criminal case took another 8 months to resolve. He did not go to trial. His attorneys negotiated a plea, reduced charges, a significant fine, mandatory community service, and a 3-year supervised probation. No prison time. I know some people hearing that will feel it was not enough. Maybe they are right. I have thought about it from many angles, and I land always in the same place. It is not mine to decide. I am not the judge of what is enough. What I know is that there was accountability, that the thing was named, officially, as wrong. That Brandon Carter stood in a courtroom and entered a plea and heard a judge tell him what he had done. Clifford Hess lost his law license. That, somehow, felt more final than anything else. The specific professional consequence for a man who had used his profession as a tool for exploitation. His license was the thing he had used to do the damage, and it was the thing that was taken. I did not attend Brandon's hearing. Patricia offered to come with me if I wanted to go, and I thought about it carefully and decided not to. Not out of disinterest, I was very much interested in what happened, but because I understood that attending would mean putting myself back in the same room as a process I had finally, genuinely released. The hearing was not about me. It was about what had been done to Richard, and what it meant under the law, and what consequences followed. My presence was not required for it to be real. I found that out, I realize, is one of the most significant things I learned that year, that your presence is not required for something to be real. You do not have to witness every consequence to know that it happened. You do not have to be in the room for the accounting to occur. Sometimes the most powerful thing you can do is step back and trust that the world, imperfect, slow, frustrating, inconsistent, will do what it is supposed to do. I had spent 41 years making sure I was present for everything, being the person who managed things, handled things, held things together. There is great value in that. There is also a cost. Learning to let something be handled by others, learning to believe it would be handled, was its own small revolution. What? The foundation came from Dorothy Harmon, of all people. We had stayed in occasional contact after the case. She had been a key witness, and I had called to thank her properly once everything was resolved, and we had discovered, somewhat to our mutual surprise, that we liked each other. She was sharp and dry and had very little patience for nonsense, which are qualities I respect deeply. She called me in the spring, about 6 months after Brandon's plea. "I've been thinking," she said, "about something you said once, when we were going through the financial records. You said Richard spent 20 years building things he hoped would matter after he was gone." I remember. "Have you thought about what that means for you? What you want to build?" I hadn't in those terms. I had been so focused on protecting what existed that I hadn't spent much time thinking about creating something new. "What are you suggesting?" I asked. "I'm suggesting," Dorothy said, with the briskness of a woman who has thought this through and is presenting a finished plan, "that you have significant resources, a clear understanding of what happens when elderly people are isolated from their own financial and legal decisions, and presumably some interest in making sure it happens to fewer people." I was quiet for a moment. "I'm not a foundation person," I said. "You weren't a courtroom person either," she said, "and you spent 5 months in one." She had a point. The Richard Carter Foundation for Elder Financial Protection was not a large organization, at least not at first. It was, in its early form, essentially Dorothy's brains and organizational skill, my resources and my story, and a small advisory board that included Patricia Voss, Gerald Marsh, and Martin Fole. What it did was straightforward. It funded legal representation for elderly individuals whose estate rights were being contested or circumvented, provided financial literacy resources aimed at older adults managing significant assets, and worked with a small network of attorneys and financial advisors to identify the warning signs of what had happened to Richard: isolation, document irregularities, the quiet insertion of a third party between an older person and their professional contacts. I gave a talk at a community center about 6 months after we launched. About 40 people, mostly older, mostly the age I was or older, seated in folding chairs in a room that smelled like coffee and floor wax. I stood at a little podium and told them what had happened. Not the legal version, the human version. The part about sitting in the plastic chair in the hospital at 6:47 in the morning. The part about the codicil Richard had put in place, quietly, without telling me, because he had been trying to protect something and hadn't known how to ask for help. The part about what it feels like to have your son look you in the eye and tell you that you don't have a right to the house you've lived in for 27 years. I had given prepared remarks. I did not use them. I just talked, the way you talk when you're telling something true, and the room was very quiet. And at the end, a woman in the third row, maybe 75, white-haired, with the hands of someone who had spent a life working, started to cry, quietly, without apparent embarrassment. Afterwards, she found me by the coffee table. "My daughter," she said. "She's been doing something similar, not as dramatic, but the things you described, the calls she intercepts, the way she talks over me to the lawyer." "Do you have an attorney?" I asked. "I didn't think I needed one." "You need one," I said. "Call this number." I wrote Patricia's office on the back of a business card. "Tell them Evelyn Carter sent you." She folded the card carefully and put it in her purse. And I stood there by the coffee table in a room that smelled like floor wax and watched her do it, and I felt something I hadn't felt in a long time. Useful. Not in the way of keeping a household running or managing a legal case, but in the way of having been through a thing and being able to turn it outward. Being able to say, "This happened to me, and here is what I learned, and here is how I can help you not be alone in it the way I was almost alone." It has been 14 months since the ruling. 16 since Richard died. I want to tell you what my life looks like now, not because it is remarkable, but because I think it is honest, and I have promised myself, after everything, to keep being honest. The house is mine. I wake up in it every morning, and I walk through it, and sometimes I still turn a corner expecting to see Richard in his office, bent over the newspaper, clearing his throat at something on the front page. He is not there. That does not get easier in the way people say things get easier. It gets different. You get better at carrying it. That is not the same thing, but it is something. The garden is the best it has ever been. I have accepted that this is partly because I am putting energy into it that used to go into managing other people's happiness, and that this is okay. Dorothy and I have lunch every other Wednesday. Martin and I talk on the phone most weeks. Patricia Voss is on the foundation board and sends me books she thinks I will like. Gerald Marsh comes to the annual review meeting every January, which is, I think, what Richard would have wanted. I think about Brandon. I want to be clear about this too, because I think it would be easy to end a story like this with a clean severance. The villain banished, the protagonist moving forward unencumbered, no messy emotional residue. But that is not real, and I have no interest in unreal endings. I think about Brandon. I think about the boy he was, and the man he became, and the distance between those two things that I cannot fully account for. I think about the phone call at 9 at night when Richard told Martin he had made a mistake, and I wonder whether the mistake Richard meant was the will or something older than that. Some parenting decision, something given or withheld in the years of Brandon's raising that planted the seed of what he eventually became. I do not know the answer to that. I have stopped believing I will find it. What I know is that I did not cut Brandon out of my life, which will surprise some people and which I do not entirely know how to explain. I did not forgive him, not in any complete or tidy way. I did not resume the relationship as if nothing had happened, because something had happened, and pretending otherwise would be its own kind of lie. What I did was leave a door, not open, not flung wide, not welcoming, but unlocked, because he is my son, and because I am a woman who has learned over 68 years that the things you close permanently tend to haunt you differently than the things you leave with the option of return. And because Richard, in his methodical, careful way, had left a door too. The codicil, the locked door with Gerald's name on it. And that door had saved me. Leaving doors is not weakness. Sometimes it is the most deliberate thing you can do. Brandon has not walked through mine. Maybe he will, someday, when enough time has passed and enough has been reckoned with. Maybe he won't. That is not in my hands. I want to talk to you directly now. If you've been with me through all of it, from that hospital room at 6:47 in the morning to this garden in October with the roses dropping their petals, then I owe you something honest. Not a lesson wrapped in a bow, not a tidy takeaway. Just what I actually believe, after living through what I lived through. I believe that money reveals character more reliably than almost anything else. Not because money is the most important thing, it isn't, and anyone who has sat in a hospital room watching someone they love go quiet knows that. But because money is the thing people think they can get away with taking. It is abstract enough to lie about and specific enough to fight over, and the moment it becomes available, you find out very quickly who the people around you actually are. I believe that the instinct to keep the peace, to smooth things over, to not make a fuss, to give your child the benefit of the doubt one more time, is both the most human impulse I know and one of the most dangerous. I love my son past the point where the evidence warranted it. I am not ashamed of that exactly, but I want to be clear about it because I think there are people listening to this who are doing the same thing right now, who are explaining away the red flags because the alternative is too painful to look at. Look at it, please. It will hurt. But the alternative? Finding out when it's too late. When the document has been signed and the money has moved and you are standing in a courtroom trying to explain something everyone should have seen years earlier, that hurts so much worse. I believe that older people, people my age, the age of my parents' generation, the age of the woman in the third row with the working hands and the daughter who talks over her to the lawyer, have the right to their own decisions, their own assets, their own dignity, not as a legal abstraction, though it is that too, but as a fundamental matter of who they are and what they have earned. No one, not a child, not a caregiver, not a well-meaning family member who has convinced themselves they know better, has the right to make those decisions for someone else without their genuine, informed, uncoerced consent. Richard could not protect himself at the end. He was sick and tired, and someone he trusted exploited that. But he had tried to protect himself beforehand, in the careful, methodical way he did everything. And that attempt reached forward in time and saved what he had built. That is the thing I will carry with me forever, that it is never too early to protect yourself. The codicil Richard added 14 months before his death. The conversations you have with your attorney before you need them urgently. The records you keep. The people you tell. The instructions you leave behind that say, if something looks wrong, it probably is, and here is how to prove it. Those things matter. Those things are not pessimism. They are love, expressed in the way of people who understand that love without structure is just a feeling, and feelings can be manipulated. Structure cannot be manipulated as easily. Gerald Marsh could not be manipulated. The signed, notarized, filed codicil could not be manipulated. Richard had understood that even at the end, even when his hands were unsteady and someone was positioning a different document in front of him, he protected me the best way he knew how, and I protected everything else. It is evening now. October, the light going amber and low over the back garden, the pear tree in the far corner throwing a long shadow across the grass. I am sitting on the back porch with a cup of tea, which is the thing I do in the evenings now that I have evenings back. The roses are mostly done for the season, but the garden still smells like something alive, that particular late October smell of turned earth and cooling air that I have loved for as long as I can remember. I put my hand on the porch railing, old wood, slightly rough under my palm. Richard and I painted this railing together the summer we moved in, badly, arguing about the right way to prep the surface, ending up with paint in each other's hair, and on the flagstones below, laughing in the way you laugh at the beginning of things when even the mistakes feel like part of something good. 27 years ago, more than half my life. He is gone, and I am still here, and the railing still holds, imperfectly painted and repainted many times since, holding as things hold when they are built with some actual intention behind them. I think that is what I want to leave you with. Not a triumph, not a tidy resolution, but this. A woman on a porch in October, still here, still in her house, still tending her garden, still, after everything, in possession of her own life. That is what I fought for. That is what Richard tried to protect. That is what justice, when it finally came, gave back to me. Not the money, not the house exactly, but the simple, irreplaceable fact of a life that belongs to me. A future that is mine to decide. A door I can open or close as I choose. I choose to stay. I choose to build. I choose to turn what was done to me into something that helps someone else not stand alone in it. That is enough. That is more than enough. That is everything.